everyone welcome Nico. Our distinguished panellists include John Lowe of International Arbitrator Mediator of Lowe Arbitration in France. Everybody welcome John. Ravindra, Kumar, partner of Gunnercooke UK. Everybody welcome. Partner and Head of International Arbitration of Rowe Merchant Partners in India. Everybody welcome Palash. And Dipesh Jalansi, Founding Partner of Lincoln Rowe UK. Please join me in extending them all welcome of applause as I hand it over to Mr. Mooduto.
Nice to see you. All right, thank you. Yes. Okay, thank you very much. All right, while we're waiting for everyone to come back, why don't we just start? Good morning, ladies and gentlemen. Thank you for your time and attention. My name is Nico Mooduto. I'm a partner with SSEK law firm, which is a law firm based in Jakarta, Indonesia, a country of almost 300 million people. I will be your moderator for this panel, and I would like to extend my thanks to the committee for this opportunity. It is an honor to moderate this panel that comprises a powerhouse roster, as you could see on the podium in front of you. Today's topic is cross-border arbitration and international dispute resolution, key trends in 2025. Now, just to sort of set the scene up for all of you, if you could go back a year prior, 2024 was a very interesting year as 60 countries in the world held general elections. Now, 2025 is equally interesting as we are facing the aftermath at the front end of those elections. And we've seen a number of policy decision changes, which includes changes in the arbitration space. Now, there are many arbitral institutions around the world that have undergone changes to the arbitral institutional rules. I, for one, can say that in Indonesia, our arbitral institution has just introduced new rules to the BANI arbitration rules. I understand also in Singapore, which is a 1-hour plane ride from Indonesia, its SSEK arbitral institution also issued its amendment to the arbitration rules, and Palash will be addressing that particular topic today. Now, over to Europe, the UK also has a new arbitration act. There are many changes, as I understand it, and Dipesh and Ravindra will be addressing new changes as a result of the UK Arbitration Act. And that going sort of slightly to the east, where John is from, or where John is based, rather, not from. You're an American who lives in France. There are some developments as well in France, also a leading arbitration center, and John will be addressing that particular topic. Now, with that said, I hope I've set the scene enough for you, and let's start with the GMT folks, the UK Arbitration Act. So let me invite Dipesh to address new changes as a result of the UK Arbitration Act, and in particular, if you could address the arbitrator disclosure requirements, we'd appreciate that. So over to you, Dipesh.
Oh, thank you very much, Nico. Thanks for the kind introduction. Yes, I'm Dipesh Dosani, founding partner of Lincoln Rowe Solicitors. We are based in London on Chancery Lane, focusing on litigation and arbitration. And as Nico mentioned, there's been a lot of change around arbitration globally, and in the UK we've had the Arbitration Act 2025, which represents the most significant update on the arbitration framework in nearly 3 decades. It came into force on the 1st of August this year, and whilst it's evolutionary rather than revolutionary, the reforms are carefully calibrated to modernise the earlier Arbitration Act 1996 to enhance procedural efficiency and reinforce London's status as a leading seat for international arbitration. So I'm going to break down some of this Act into 4 key areas, and first is why the reform was needed. The Arbitration Act 96 served the UK well, but the legal and commercial landscape has evolved vastly over the years, and other jurisdictions like Singapore, France and Switzerland have modernised their arbitration laws. Following a review by the Law Commission, which underpinned the 2025 Act, it identified areas where there was need for clarity, efficiency and alignment with international best practices. And the goal here wasn't to overhaul what was already a functioning system, but simply to fine-tune it to ensure the UK remains competitive, attractive and responsive to the needs of international parties. So the key reforms of the Act start with the governing law. One of the most impactful changes is the introduction of a default rule for determining the governing law for arbitration agreements. So unless the parties expressly agree otherwise, the law of the seat will govern the arbitration agreement. And this new rule aligns the UK with other jurisdictions like France and provides greater predictability for international parties. There are now summary dismissal powers, so tribunals now have express statutory authority to dismiss claims or defences with no real prospect of success. This mirrors the summary judgment test in the English courts. It's a welcome tool to eliminate frivolous claims early, saving time and cost, as without this the parties would have to incur tens of thousands, if not hundreds of thousands of pounds for the entire arbitration. We also have the new introduction of emergency arbitrators, which formally recognises their role, empowering them to issue orders and enabling UK courts to enforce those orders. And this aligns the UK with international practice and strengthens the availability of urgent interim relief. Turning into the arbitrator immunity and disclosure, the Act now codifies the duty of disclosure, requiring arbitrators to disclose any circumstances that might give rise to justifiable doubts about their impartiality. It also extends arbitrator immunity, protecting them from liabilities for costs unless they act in bad faith or resign unreasonably. It encourages independence and confidence in the process of arbitration. There's a limit on the scope of jurisdictional challenges, as courts will no longer entertain new objections or evidence unless it could have been presented earlier, which reduces duplication and delay whilst preserving fairness. So these reforms aren't just technical, they have real-world implications for international parties, as there's legal certainty with the governing law clarification, reducing the risk of conflicting interpretations and forum shopping. The efficiency is there because the summary dismissal and streamlined jurisdictional challenges reduce a procedural drag, and access to urgent relief. Emergency arbitrator recognition ensures parties can obtain enforceable interim measures quickly, and there's greater confidence in arbitrators as there's codified duties and protection that enhance trust in the neutrality and independence of the tribunal. Importantly, the changes apply only to proceedings commenced after the 1st of August, so parties should review their existing arbitration clauses and consider whether updates are needed. So, in summary from my side, the Arbitration Act is a thoughtful, targeted update which enhances clarity, efficiency and competitiveness. For international lawyers and their clients, it offers a more predictable and streamlined arbitration environment, to one that reinforces the UK's role as a premier destination for resolving cross-border disputes. Thank you.
Thank you, Dipesh. Sorry, I was remiss on not introducing Dipesh more elegantly. I should have said Dipesh is the founding partner of Lincoln Rowe, a law firm based in the UK. Dipesh has proudly been awarded the ACQ5 Award for Commercial Litigation of the Year for a number of years. and his specialist areas include commercial litigation and insolvency litigation. Dipesh also advises clients on a wide range of commercial disputes, and your articles have been featured in the Law Gazette as well as the Solicitor's Journal. Now, if I could now hand it over to Ravindra. Ravindra, you are a partner at Gunnercooke, also based in London as well. Ravindra has spent over 23 years representing and advising clients on cross-border disputes and international arbitrations. Ravindra is a dual qualified lawyer and advocate in India and a solicitor in England and Wales. His expertise include disputes in joint ventures and shareholder disputes, and has a proven track record representing domestic and international corporations. Now, while we're still on the topic of the UK Arbitration Act, Ravindra, could you perhaps address to the audience any missed opportunities without sounding overly critical of the rules itself, because it's an amendment, but the floor is yours, sir.
Thank you so much. Instead of criticizing, I think Dipesh left with me nothing to add. He has covered almost everything, except
Sorry about that.
what I can add is that the new arbitration changes, which are very much required and needed, also brings a lot of immunity to the arbitrator. It saves them from cost consequences in certain circumstances if they have to resign or if they have to be removed. So I think that's and the emergency reliefs which now arbitrators can pass to protect the subject matter and disputes is a welcome step, and it brings at par with other jurisdictions. There is one also change in relation to for the jurisdictional challenge, as Dipesh has said, that parties do not have to relitigate and address all the issue on the jurisdiction, and only those arguments which were not before the arbitral tribunal or with the submission which has not been made before the arbitral can only be addressed in case of arbitration challenge, jurisdictional challenge. I think that's all from my side, because Dipesh has very nicely covered everything else on this. Thank you so much.
Yeah, thank you, Ravindra. Now, moving on to Singapore, the SIAC also introduced new rules, and this is time for Palash to address.
Thanks, Nico. Thank you. Hi, everyone. By way of introduction, I'm Palash Gupta. I'm an Indian-American lawyer, went to law school in India, and must have liked the experience so much that after going in-house for 4 years with Unilever, I decided to move to Boston and repeat the process all over again. Somewhere along the line at 30, I looked at myself in the mirror and said, that's 8 years of my life, I am never getting back. I litigated in Massachusetts State and Federal Court for some years. And did some AAA and JAMS arbitration, and then my wife and I moved back to Asia. And I focus most of my practice today on Singapore and India-centered international arbitration. And that's what I want to talk to you about today. Our topic involves recent trends in international arbitration and dispute resolution. Now, I always tell my students, because I teach at a law school, when clients come in to arbitrate, what do they pay for? It's a more expensive process than litigation, because you pay for your institutional costs and you also pay for your arbitrators, which is something that you don't need to do when you litigate. But what do you pay for? You make the payment because you pay for speed, you pay for efficiency, maybe impartiality, and some expertise. And I don't think these trends will ever get old. They just continue. And I'd like to discuss these continuing trends in light of the latest Singapore International Arbitration Center rule revamp. Look, the SSEK has been, I would think, the dispute resolution forum of choice for some years in Asia at this point. Kind of taken over a bit from Hong Kong, there are competing interests. And the nice thing about the institutional centers in Asia is because there's so much work coming in, they're always working with each other to get a little more efficient and make the process easier for users. Sorry, you're just way too close to me. It's my focus issue. Yeah. The SEAC came up with a new set of rules in 2025. And a couple of things I'd really like to point out. First, they introduced something called the streamlined procedure. How many of you guys in the crowd are familiar with streamlined procedures for international arbitration, or have actually participated in one of them? None? One? Half? All right, we're getting there. Behind me? All right, there you go. All right, John's been there, done that. Fair enough. So streamlined procedure is an expedited version of the expedited arbitration. Okay? And the SEAC didn't have this in its rules before. To that extent, it's caught up with the ICC, whereas some of the other rules haven't done that yet. For the streamlined procedure, either parties opt for it, or the SEAC will impose it if the total value of the sum in dispute is under 1 million Singapore dollars, which sort of translates roughly out into 750,000 US. Yeah? Under the streamlined procedure, they've really crunched timelines. So an arbitrator is appointed within 3 days of the filing of the notice of arbitration. If the parties can't agree on an arbitrator within 3 days, surprise, surprise, the SEAC will appoint one as soon as practicable. Once the arbitrator is appointed, he or she has 5 days to start the case management conference. And the award comes out within 3 months of the arbitrator being appointed. Talk about pressure. Eh? To make sure this happens, they've cut down on some of the procedures. So no disclosure of documents. So your red fern schedule goes out of the window. No fact witnesses, no expert testimony. And when you take away all that, you have no fact witness statement, you have no expert testimony, you have no document production. You also then don't need the final hearing. So it effectively becomes a document-only arbitration based on pleadings and evidence. Now, the sum in dispute doesn't necessarily dictate how complicated a matter is. You could have a small sum dispute, but it's still complex. So the SEAC has fortunately left a window open for the SEAC president to decide that even a small value suit can't be run through this process, so you can stick to the traditional arbitration. Yeah? So there is a way out. It isn't a hard and fast rule. The second thing they did, other than the streamlined procedure, was to expand the scope of expedited arbitrations. I've done a couple of expedited arbitrations in Singapore. They're open to a little bit of misuse sometimes because claimants come before the SEAC and say, well, we don't know the value of our suit. Let's push for the expedited procedure because, hey, we are the claimants. And a couple of times in the past, I thought SEACs ran a little too quickly to try and give them their wish. Earlier, the ceiling for the SEAC expedited process was 6 million Sing. And now, under the new 2025 rules, they've pushed it to 10 million Singapore dollars. Okay? For context, that translates out into 7.8 million US, 6.6 million euros. Yeah? What's the difference between the streamlined process and the expedited arbitration process? The expedited arbitration process is actually the entire process. You still file your pleadings, you can have fact witnesses, you can have expert witnesses. Yeah? It's not a document-only arbitration. It will be by a sole arbitrator, and the arbitrator has 6 months to pass the award once that he or she has been appointed to the position. Okay? By pushing this limit from 6 to 10 million, you may actually end up with fairly complicated arbitration procedures. So parties have the right, under the SEAC rules, to object to the application, to an expedited procedure being put into place, but that's at the discretion of the arbitrator. And frankly, most of the ones I've been involved in, the arbitrator has been really happy to go through with it. So we come back to the pillar of speed. You're paying for speed. You're doing an international arbitration, you're paying high costs, you pay for speed. And I think the first thing that the SEAC has done is push speed. You now have a streamlined process, you've widened the scope for an expedited process. What's the third thing they've done? In the past, when you applied to have an emergency arbitrator put in, you could only do this under the SEAC rules in conjunction with or after the notice of arbitration had been filed. Okay? SEAC's caught up with ICC. Now you can file an application for appointing an emergency arbitrator even before you file the notice of arbitration. And why would you want to do this? Think of a shipping case. Yeah? A ship comes into the Manila port in the Philippines. The purchaser doesn't want to download the supplies saying, hey, this is not what we asked for. The seller needs to download and get the ship out of port because it's incurring demurrage charges by the hour, by the day. Okay? Who's going to wait for the notice of arbitration? You'll be bankrupt by the time it happens. So the first thing you can do now is file an application, have an emergency arbitrator put into place. It's not cheap. I think 25,000 Singapore dollars to accompany the application as a fee. And then the arbitrator, who's appointed within 2 days, just as an emergency arbitrator, then has the option of directing the parties to either unload the ship or to take the goods back. Okay? The last thing that they've done on the speed aspect is they've allowed the emergency arbitrator to pass ex parte awards. This wasn't possible before. In the past, when an emergency arbitrator was appointed under the SEAC rules, both parties had the right to appear before the arbitrator and present their cases. Now, ex parte orders can be passed to protect the subject matter of the dispute. It's limited in scope, but I think these are great changes because the one thing they've done is they really helped you to kickstart the process right from the beginning. Okay? You don't have to fight over arbitrators, you don't have to fight over the seat, you don't want to fight over the lex arbitrae, somebody's goods are rotting somewhere else. I once had a client and she had a brilliant story. She is the general counsel of a brewing company, and several thousand cans of beer were the subject matter of the dispute. And she needed to get an ex parte award and an emergency arbitrator award to protect the beer that was sitting and rotting in a warehouse. Sad part of the story is by the time the arbitration ended, the beer was spoiled anyway, but that's just the way life plays out sometimes. So, in short, the focus of the new SEAC 2025 rules replacing the old 2016 SEAC rules has been on speed. Let's get things moving quicker. The second thing that they've done is they've also worked on efficiency a little bit. Okay, two aspects to this. One, how many of you have been involved in consolidated arbitration proceedings before an institution? Same parties, roughly the same issues, but multiple arbitrations. So you're running the risk of having differing awards. Yeah? You can file an application under most rules, including the SEAC, the LCIA, and the ICC, to consolidate your arbitration so there's no duplicity of proceedings or potentially duplicity of awards. It's not always possible to file a consolidated application quickly, and the tribunal may not agree. So now, for the first time, in the interest of efficiency, let's say our second pillar when you go to arbitrate, the SEAC has decided that you can file for coordination of proceedings. You don't need to go for consolidation. What's coordination of proceedings? Same parties, same issues, multiple tribunals. File an application to have one in abeyance and stay it. File an application so that you can coordinate the arbitrations and do them sequentially, so you reduce the risk of potential conflicting awards, or file an application for the two of them to be held concurrently. All right? Takes away the need for consolidated applications, which is a slightly complicated process. Last one, in the interest of speed and efficiency. Okay? Change the rules on appointment of arbitrators. In the past, because the arbitration agreement is often king, the SEAC was very hidebound on following the precise procedures which the parties had agreed to in terms of nominating and nominating arbitrators. Appointment is done by the institution. Yeah? The problem with this is that if the parties are in an unequal bargaining position in a contract, which often happens, the procedure which has been agreed upon for nominating an arbitrator is badly skewed in favor of one party over the other. Yeah? Because it's a contract at the end of the day. It's a creature of agreement. For the first time, I think it's Rule 19, SEAC has stepped in and said, if we review a clause on application which seems to be completely skewed in favor of one party over the other, we will step in, scrap the arbitrator nomination process, and have the president of the Singapore International Arbitration Center appoint the entire panel, the entire tribunal, whether it's one or three. And parties will be deemed by legal fiction to have waived their right to nominate an arbitrator. Yeah? Big changes, big changes. If you've arbitrated in Asia, these are big changes. You now have a streamlined process which you didn't have before. You've widened the scope of the expedited process. And if you've got a skewed arbitration agreement, which skews in favor of one party while nominating an arbitrator, the SEAC will step in, and if Singapore is your seat, your lex arbitrator is not going to set aside the award on an application. Thanks.
Thank you for that explanation, Palash. Now let's move on to France, where John is based. Go ahead.
Thank you, Nico. Yes, as Nico mentioned, I'm based in France, and it may seem a little strange to have an American talk about developments in France, but for any of those of you who have gone to Paris Arbitration Week, you will have noticed that probably 90% of the panels are conducted in English. I would hazard a very unscientific guess that at least 50% of all arbitrations taking place in Paris are being conducted exclusively in English. Then French, probably Spanish is the third language. So France is, again, it's competing with London and Singapore to be a major locus for international arbitrations. I'd like to make three general comments here. Let me just talk a little bit about some of the cases that have been dealt with by France. I would say in terms of challenges to arbitral awards, there have been probably, they are looking at disclosures, and we'll talk about arbitrator disclosures a bit more. There was a famous, a relatively well-known case in which an arbitral award was overturned. It actually occurred, you may remember that a couple of years ago, Manuel Gaillard, a very, very prominent arbitrator and practitioner, unfortunately passed away. During the course of his remembrance, a very prominent arbitrator gave a eulogy commemorating Gaillard's work. The problem was that this arbitrator had just issued an award. He was the chairman of a panel in which Emmanuel Gaillard was one of the counsel. And after a lot of hemming and hawing, the Paris Court of Appeals overturned that award on the grounds that the arbitrator had not disclosed his very close personal relationship with Emmanuel Gaillard. Basically, this is a trend I think you're going to be seeing in many other jurisdictions as well, is that there is a tremendous effort to bolster arbitrator disclosures. This was also true in the new English Arbitration Act, where there's a much greater emphasis on disclosures. A couple other areas of comment in French awards. Corruption and money laundering have always been issues where the Paris Court of Appeals likes to get involved. They did recently overturn an arbitration award in favor of an investor on the grounds that he was using the bank, which was the subject of the investment arbitration, as a means of money laundering. However, there was a more recent case in which Libya, again involving an investment arbitration, and Libya had argued that the investment was contaminated by allegations of corruption. The Paris Court of Appeals actually refused to overturn this award, saying that it would have been up to the arbitral tribunal to deal with those allegations and not the court. So in essence, they seem to be walking it back a little bit from their prior interest in getting into all the details of allegations of corruption. Okay. Okay, let me stop there. Another issue that's going on in France right now, somewhat similar to what's happening in the UK or in England, is that the French Arbitration Act, or the French arbitration law, because there is no French Arbitration Act, it's included in the Code of Civil Procedure. There is an ongoing effort, and moving actually quite quickly, to renew and promulgate a brand new French Arbitration Act. Several drafts of this have already been presented. There was drafts presented during Paris Arbitration Week. And the objective of this is to put all the pieces of the French arbitration law in one section, and to also clarify and basically make domestic arbitration and international arbitration to treat them somewhat the same. A couple of things of note is that the proposed changes will actually accord with what's going on in French law right now. If the procedure, if the arbitration is being seated in France, then French procedural law will apply to the arbitration, and that would be included in the new law. Another important fact, element that I think is noteworthy is that France in the past has actually occasionally recognized arbitral awards that have been annulled in the seat where they took place, and the French, the proposed French law would actually put this into the law, so they would retain the ability to recognize awards that have been, even if they have been annulled in the place where they were issued. The third change I would like to mention very briefly is at the end of August, there was a new decree issued on the subject of mediation. And basically what is happening in France, as has happened in other jurisdictions, is that the courts are under increasing pressure to get rid of their caseloads, and they do view mediation as a way of trying to move things along, have cases settled that don't necessarily need to be heard by a judge. The big change in this new mediation decree is that it gives the judge the authority to force the parties to go into at least a preliminary mediation hearing. There are still some unanswered questions as to how this will work, how it's going to be financed, who's going to pay for it. And I'm sure, actually next week I'll be attending a conference dealing with some of these issues. But the point is that the French courts now do have the authority to force the parties at least to participate in an initial discussion of mediation and whether it might be applicable to their case. The alternative is they would have to pay a fine of up to 10,000 euros if they do not appear or do not present a valid excuse. So I'm going to stop there right now. We can get into some of if you have any further questions about what exactly the proposed changes in French arbitration law would be. But again, cases are continuing. The French courts are continuing to pay attention to requests to overturn arbitral awards, but they maintain a very arbitration-friendly perspective. I would say disclosure issues are a major concern. Corruption seems to be a little less noteworthy than it has been in the past, and the fact that France is modifying and will be putting into one set of laws its entire body of law dealing with arbitration, and also the push to mediation. These are the main subject areas in France right now. Thank you very much.
Okay, thank you, John. We focused on rule changes, country-specific or institutional rule-specific. Now, on a wider international scale, there are changes to the IBA rules or an arbitrator conflict and disclosure requirements. Now, Palas, would you like to address the audience on a few changes from that?
Sure, thank you. Okay, so sticking to the theme on arbitrator disclosures and impartiality, let's go back to what I had said when I started the last time. You pay for speed, efficiency, expertise, and potentially impartiality, right? So the trend that you look at in international dispute resolution is how do we strengthen each one of these pillars. We talked a bit about speed, we've talked a bit about efficiency. the next step is arbitrator impartiality. We've had both John and Dipesh talk a little bit about how legislation in the UK and in France has been strengthened to strengthen arbitrator impartiality. Now, how many of you, and I think I'll get a better response than the half last time, how many of you have had experience in your arbitrations with the IBA rules? On a number of things: collection of evidence, document production, and impartiality and appointment of arbitrators. Anyone? Everybody. Okay. See, John goes again. All right. So, the IBA rules are often read in conjunction with applicable legislation, and at least in some of the matters that I've participated in, though they have no force of law, the arbitrator often, in the case management conference, or when issuing the terms of reference, simply puts out a statement saying parties will abide by the IBA rules on the following 3 or 4 topics. One of them is the IBA rules on the appointment of an arbitrator, and on impartiality. The IBA rules are updated in 2024, and they've always had a traffic light system which they use to decide whether an arbitrator can be put on a panel, disclosure-wise. So there are 4 categories, effectively. There's the red list non-waivable, there's the red list waivable, there's the orange list, and there's the green list. Those are the 4 categories. And if an arbitrator falls during the time of appointment, when the disclosures are reviewed, if the arbitrator falls within the red list non-waivable category, in that the arbitrator has an identity similar to one of the parties, as the name suggests, the opinions of the parties are irrelevant, you'll never be able to appoint that arbitrator. The red list waivable flips the script. There appears to be a disclosure, but if all the parties agree, the arbitrator can be appointed onto the panel. The orange list is where the changes have occurred. What's the orange list? The orange list is a series of potential conflicts which have been outlined, but here, unlike the red list waivable, the party gets appointed, the arbitrator can be appointed unless one of the parties object. So for the red list waivable, the arbitrator won't be appointed unless all the parties agree. For the orange list, the arbitrator will be appointed unless one of the parties raises an objection and the institution accepts the objection. So what the latest IBA rules have done, and when I say latest, the 2024 updated version on appointment of arbitrators, is that they've massively expanded the orange list. And the expansion is kind of in keeping with the legislation in the UK, the United States, and in Singapore to strengthen arbitrator disclosures. What it basically does in the orange list is to require the arbitrator to make more and more disclosures, and it also imposes an obligation on parties to have constructive knowledge of potential conflicts. So by increasing the orange list, but by leaving the red list and the green list largely untouched, what the IBA rules have done is to say, look, in that sort of middle ground between is the arbitrator compromised or not, we'll expand that middle ground. So you have to increase your disclosures and give the parties a chance to raise a cogent objection. And this goes to the strengthening of the 4th pillar, that one of impartiality. Thanks.
Thank you, Palash. Now we've been discussing procedural rules and key updates on procedural rules and arbitration legislation of various countries. Now let's move on to enforcement. Now, John, can you, in your experience, can you address recent cases in which awards were set aside, and on what grounds, and what arbitrators, such as yourselves, can do to mitigate enforcement risks?
Okay, thank you, Nico. Again, I think what I'll do is start by, I mentioned earlier that one of the major grounds that recent cases are addressing are attempts to set aside awards on the basis that there has been inadequate disclosure by the arbitrators. And again, Palash was mentioning it's not so much, it's case law in France, it's case law in the United States, it was case law in the UK, right now it's encompassed in the new Arbitration Act. But there have been a number of cases, there was one in the United States, Mountain Energy, where an arbitrator was, it was part of the JAMS organization, and as a arbitrator under JAMS, he was actually a part owner of JAMS. He did not disclose the fact that he was a part owner, and the award was eventually set aside for his failure not to disclose that fact. This case is probably not going to have much more significance because all JAMS arbitrators are now actively disclosing the fact that they have a very, very small percentage ownership in the JAMS organization. As an arbitrator appointed in a number of US-based arbitrations, I must say that the lists of questions that are being provided by the institutions, whether it's the CPR, whether it's the American Arbitration Association, whether it's the Financial Regulatory Authority, but the number of questions that are being proposed, which all prospective arbitrators need to answer, are very extensive. You have 4 or 5 pages of questions. Do you know any of the parties? Have you had any relationships with the parties? Do you know any of the other arbitrators? Do you have any relationships with them? Have you had similar cases involving either yourself as an arbitrator or a party? What percentage of work do you give to a particular industry? So the questions are becoming, from my perspective, much more intrusive, but you have to go ahead. And a question, I think, is an open question is, if you, and sometimes you have to, you have to list your potential conflicts. And the question is, to what extent might these, even if they're relatively minor conflicts, to what extent might they influence the possibilities that you will be appointed as an arbitrator? That's an open question. I would like to mention, I was reading recently of a case in Germany which was set aside, and this was a complicated case arising from an acquisition agreement in the pharmaceutical industry, and it related to various tests that would have to be conducted by the buyer of the pharmaceutical company going forward in order that the seller would be entitled to certain earn-out arrangements. And again, it was a complicated case, but the German court that reviewed this arbitral award eventually annulled the award on procedural grounds, and the procedural grounds for which it annulled the award eventually boiled down to 2 or 3 major issues, but a lack of procedural due process was the main one, on the grounds that a couple of the arguments of the respondent were not given due consideration by the tribunal, that a requirement of the burden of proof shifting, which apparently the tribunal implied but never stated, was not mentioned by the tribunal. So the court found that the fact that the tribunal never mentioned some of the arguments made by the respondent, never dealt with the fact that they implicitly applied a shifting of the burden of proof without stating the basis for which that shifting should have occurred, was enough to result in the annulment of this award. What it means to me is that tribunals need to continue to be very careful in how they formulate their arguments. They need to pay attention to what are the arguments being put forward by all of the parties, and they need to address those. And another point that came out through this, and I see this in some awards, is the burden of proof is not always very clearly set forth in the arbitral award. So tribunals need to be very clear about who has the burden of the proof and what is the legal basis for that burden of proof, And if there's going to be a change in that burden of proof on the basis of legal of a legal rationale, they need to state it very clearly. So that's what I would like to say. A couple of other points I would like to say is, again, from what I see in case law, there are a large number of attempts to overturn arbitral awards, but by and large, many of these are unsuccessful. And I did mention earlier the Libyan case involving allegations of corruption. And again, this was not overturned by the French Court of Appeals. I'll stop there. If anybody else wants to comment on awards that have been overturned or that have not been overturned, leave it to my colleagues.
Thank you, John. Now, over to Ravindra. Can you address, in your experience, enforcement issues, particularly arising from public policy and perhaps integrity reasons? And then one case that involved Nigeria, if you'd like to address that.
So in late, thank you. So in late 2023, the English High Court overturned $11 billion arbitration award against PNID, in favor against the state of Nigeria by PNID, primarily on grounds of corrupt practices and abuse of arbitral process. It turns out that the team in PNID, they involved in bribery and corrupt practices while obtaining the arbitration award against state of Nigeria. And there was 11-day, I think, High Court hearing in which the court turned it around and dismissed the arbitration award. Now, where does it leave us to when the parties act and put their resources in a long, drawn arbitration, and then goes back for enforcement in the court, and it's set aside. So what we need to look into is we need to be careful. We need to see from the contract drafting stage what can be done to avoid these kind of fallbacks. So we need to review the arbitration award. We need to see that the contract is compliant and is governed, and there is opportunity at every stage to the General Counsel and the councils to review and audit the processes so that it is avoid, and there has to be an active participation of the councils and the General Counsel to see that at no stage in the proceedings anything which is unfair or corrupt practice is involved. So there is to be continuous monitoring of misconduct. These are the things which the council and the team should look into it, and to avoid any regulatory or corrupt practice. So this was a massive arbitration award which has been set aside for these reasons. So I'll pass it on. Thank you.
Thank you, Ravindra. Now let's move on to AI, which is a hot topic in recent years, and the use of AI in our daily lives. So, Dipesh, would you like to address the role of AI is playing in international arbitration, the specific risks and opportunities from AI?
Thanks, Nico. Yes, artificial intelligence, I mean, it's being used more and more by the legal community, as Nico said, and also in everyone's daily life. As a show of hands, actually, who out of everyone here uses AI as part of their day-to-day work? It's everyone. But with the transformation, obviously, comes a duality, because there's efficiency and innovation on the one hand, and then you've got the ethical, legal, and procedural risks on the other, and especially in relation to arbitration. How is AI being used in international arbitration? Well, the most common applications, including, gents, if you need to add anything in, let me know, but There's obviously legal and factual research, because the tools can scan vast databases to identify relevant case law, statute, and precedents as well. Document review and e-disclosure. AI software now helps sorting and tagging and analysing those large volume of documents, which previously, and probably still do in many cases, involve paralegals unfortunately sitting in a dark room for weeks on end. There's drafting assistance. AI can obviously generate first drafts of pleadings, procedural orders and correspondence, and even submissions, although human oversight remains essential in all of these things. Data analytics are there to help review arbitrator profiles and their past decisions, and there's translation and transcription now too. So AI-powered tools are now capable of real-time translation and generating hearing transcripts at a fraction of cost to what they normally are. So these tools are there to help us. They're not to replace the lawyers or the arbitrators, but just adding to their tools, which creates a number of opportunities, and they're compelling, really, in arbitration, but all legal work, really. But the efficiencies are there as it reduces time spent on repetitive tasks. The accuracy, although AI can also make some mistakes, it can also detect patterns and inconsistencies in data that humans, we can miss. We might make mistakes ourselves. And access to justice for those under-resourced parties, AI can help level the playing field. So in summary, it can help streamline the arbitration process, making it faster and cheaper and more accessible. But we've talked about the opportunities. There's also risks and regulatory challenges with AI. Key factor of the risks, especially in arbitration, is confidentiality and data security. Confidentiality is the cornerstone of arbitration. So there's a risk that when parties input sensitive data into third-party AI tools, especially open source and cloud-based platforms, they are risking exposing that data to misuse or further breaches. There's been issues about bias and fairness, because AI systems are only as good as the data that they're trained on. So if that data is skewed, for example, reflecting historical biases and case outcomes, then the AI may amplify those biases. And so that raises concerns about the algorithmic fairness, and especially in cross-border disputes where you're not just looking at law, you're looking at diverse legal cultures. And hallucinations. I think I'm having a hallucination there. So,
You're in Amsterdam.
So what AI has been criticised for already is generating plausible sounding but fabricated content known as hallucinations. And there have been cases in English courts where lawyers have faced sanctions, some even been struck off for submitting AI-generated citations that never actually existed. So in arbitration, this could undermine the credibility of submissions or even the enforceability of awards. Smart contracts and decentralized finance. It's obviously transforming commerce, but also reshaping legal frameworks which we use to resolve disputes. And so arbitration and international arbitration is increasingly called upon to handle these types of complex disputes because they are borderless and highly technical. So the digital asset disputes are diverse and continuously evolving. The common categories include cryptocurrency fraud and recovery, trying to trace stolen tokens and seeking restitution. NFT, intellectual property disputes involving copyrights, licensing and ownership. There's contract failures where people using smart contracts, they will have code errors or execution failures which lead to financial loss. And a common one is exchange and platform liability, disputes over outages and margin calls or even user agreements. The other complications with digital asset disputes is that they a lot of the time involve anonymous parties, decentralized systems and cross-border transactions. So given the international nature of these disputes and the uncertainties around jurisdiction, the traditional litigation struggles to keep pace, and that's where arbitration can help. So why is it the preferred mechanism? Because international arbitration offers several advantages that make it well suited for digital disputes. Firstly is the neutrality and flexibility. Digital assets are inherently transnational, so arbitration allows parties to choose a neutral seat, applicable law and language, so to avoiding national courts with inconsistent crypto regulations. Confidentiality is key in arbitration, so in a space where digital asset disputes arise, there's also it's also a space where parties use pseudonyms, so arbitration's private nature protects sensitive information and trading strategies and source code. The technical expertise, parties can appoint arbitrators that specialise in blockchain and cybersecurity and digital law. Enforceability, the awards are enforceable in many countries which are signed up to the New York Convention, which is a major advantage over national court judgment, especially when assets are held over numerous jurisdictions. But with everything, it's got its strength, but arbitration also faces its own unique challenges in that space. Firstly, with jurisdiction and consent, it's establishing a valid agreement, which can be difficult when the parties are anonymous or using pseudonyms. There's also still enforcement risks. So in some jurisdictions, they ban crypto trading or equate it with gambling. So awards involving digital assets can be refused on policy grounds, especially in consumer disputes. Valuation evidence, digital assets are highly volatile and poorly regulated. So valuing loss and presenting evidence requires forensic experts, but can be very difficult. The regulatory uncertainty, the legal status of digital assets varies widely around the world. So in the UK, crypto assets are recognised as property under common law, but in the US, crypto assets may be classified as securities or commodities depending on the regulator. So to meet these challenges, the arbitration space is evolving itself, so there's some specialised rules coming into play. So the UK JT digital dispute resolution rules offer tailored procedures and optionally ability to remain anonymous and power to interact with digital assets directly, which is helpful. So arbitration there is really helpful for digital asset disputes. So they offer an opportunity for arbitration to demonstrate its adaptability, neutrality, and global enforceability. Thank you.
Yes, in answer to Dipesh's question, I actually did a very quick research and saw that a recent case has been filed in a U.S. federal court. It's called La Parlia versus Valve Corporation, which raises the question, the claimant is petitioned to vacate an arbitral award on the grounds that the arbitrator allegedly relied on AI to such an extent that he outsourced his role as an impartial adjudicator. Again, the case is still being litigated, but it raises the issue of to what extent might AI be used by arbitrators, and to what extent might those eventual awards be subject to annulment or being set aside. The other comment I would make about the use of artificial intelligence is if you use something like ChatGPT to help you write an award, you are essentially giving ChatGPT confidential information from the case. So you might argue that it's put together with so much other information that it becomes indistinguishable. But in a large extent, I do believe that you are violating your confidentiality obligations. So in that sense, if you're going to use artificial intelligence, you should use only a proprietary system which will not utilize that information outside of specific boundaries. And I think that's going to be very, very hard to police, and I imagine that might give rise to challenges in the future as well. Just a couple of comments on that.
Thank you, John. Now, moving away from AI in the tech space, let's talk about sanctions and geopolitics. We've seen a number of agreements, or at least the common practice these days is to include sanctions clauses in agreements. So you see sanctions clauses appear in commercial agreements, which arise primarily because of the condition from geopolitics. Now, to this end, Ravindra, would you like to address how sanctions and geopolitics have affected arbitration on disputes?
Yeah, I personally got a matter where my client had a sibling dispute, and it came out of a proceeding in Calcutta High Court. And when we are appointing the arbitrator, we got to know that director in my client's company was in the sanctions list. So that created kind of issue within the firm, whether we can take the matter, how do we take the matter, and how do we represent, how the arbitrator will be paid, because there is someone who is involved in the sanctions list. So the contract was already done, it can't be modified, so we had to, then I asked if we can get a license, which is provided under the US sanctions, and then I was told that because we are based in the UK, the sanction list is in the US, we can't apply for it. So then we have to go, I have to go to my American partner and ask him to take over the matter, get the license, and then I work with him. So we need to find a way around, but that's one matter. And the current geopolitical situation is leading to so many sanctions and issues which leaves litigation and arbitration into a position where there is so much uncertainty. And so we need to work on it from fairly beginning at the level of contract drafting, as my friend just said, that in many contracts we now use the sanction-friendly clauses. How that will work in actual, real and practical sense, when what kind of clause, what wordings are going to be there in that clause, that if one of the party is subject to sanction resign, will the other party pay for the arbitration? So all these questions needs to be looked into. The way to do it is, so we need to look into what is going to be the payment options, which are going to be the arbitrational institutions who have experience in dealing with sanction jurisdictions. I think LCIA and ICC are well equipped in dealing with these kind of arbitration proceedings, where one of the party is affecting the sanctions. So we need to see that when we draft, we put sanctions clauses to see that the institution is one which has an experience in dealing with sanctions list. The payments can be done in a manner. Sometimes I was in Paris last year for Arbitration Week, and we were discussing whether the payment can be done in crypto, it can be avoided, or there can be when we are doing the contract, we could keep a corpus to deal with the arbitration if it comes and is affected by the sanctions. We can work on multi-level jurisdictional, multi-level dispute clauses where we have mediation in the beginning, then followed by arbitration, where the parties can avoid the sanction resign in a manner. Obviously, if there are option of taking statutory license, that should be taken. This is from my way for the sanctions to deal with. Thank you.
Thank you, Ravindra. Now the final topic, just on updates on nature of disputes, is ESG. Palash, I understand you would like to address some sort of updates and issues arising from the ESG space.
Thank This one could be a conference topic all by itself. ESG, environment, social and governance related arbitrations, are a hot topic. It's an expanding scope in international arbitration. There have been some big cases, some involving Shell in the Netherlands, where parties have been sued for breach of contract arising out of their ESG obligations. So far, two trends to just touch on, because I think we're running short on time and this conversation would go on for a long time. Contracts, business-related contracts, are getting tougher with parties with relation to ESG obligations. And whenever you have enhanced clauses in contracts relating to obligations, at some point somebody's going to get sued for breach. Okay? The conjunction of international arbitration and ESG obligations is really this. Is international arbitration the best forum to resolve ESG-related disputes? That's the big discussion that's happening now. And I think the advantage of using international arbitration to resolve these disputes is the same argument that Dipesh used a little while back. It just inherently works with what's the advantages of going to arbitration over going to local courts to resolve ESG disputes. Okay? I think the big advantages are, if you know that you have a contract where ESG can be a major factor, you'll weave that into your arbitrator nomination process. You may have requirements that arbitrators with certain expertise, if you're a tribunal of 3, at least one of them will have ESG expertise that you can use to adjudicate the case. The second big advantage is enforceability. It's enforceability. A lot of ESG cases are cross-border and transnational, and so difficult to have court orders enforced in some jurisdictions. But because of the New York Convention, which practically everybody is a party to, you can enforce the International Arbitration Award in context of ESG matters, because these are often cross-border cases. So effectively, what makes international arbitration attractive to parties doing international business works out into the ESG case as well. You're going to try and pick people based on efficiency, on expertise, and on enforcement. There is one negative to using international arbitration as a tool to solve ESG matters, and I think it's confidentiality. I think a lot of parties, tough to play the name and shame game, but if I'm looking at ESG clauses and I'm accusing somebody of breaking social governance rules or breaking their ESG obligations, it may be advantageous to have that played out publicly in court, which might get you a quicker resolution and might give more publicity to a fast-growing topic, than to do this through international arbitration, where the alleged sins of the perpetrator never see the light of day. Okay? That's the flip side to using international arbitration to resolve ESG-related disputes. But I think this is a growing topic, and we're going to hear a lot more of it going forward. There's actually a whole volume of international cases, including, like I mentioned, the Shell case here, cases in the United Kingdom and cases in Africa, involving companies signing contracts with certain obligations and then breaching them. Thanks.
Thank you, Bash. Now let's open the questions to the floor. Would anyone want to raise their hands to ask any questions? Yeah, please.
Thank you very much for touching various aspects, and I'm much more interested in some specificities that relate to crypto assets. I would be very thankful if each of you could answer whether you have dealt with any litigation which refers to finding a crypto asset of a descendant. I would try to clarify, as nowadays the legislation says that it's an ordinary property or it's security, and alongside the applicable legislation says that people that hold cryptocurrencies are not incognito anymore, so you are basically supposed to know who is the holder of the crypto asset. What happens to that property when the person passes away? What happens with it? If it's an ordinary property without any specificity according to the applicable legislation. I mean, how do the heirs of the person get hold of it after the person passes away? How you can pledge it, etc.
Is this good question?
I've been asking it for a while, so.
We turn you over to the expert.
Yeah.
Yes, I think I might use AI to answer this one. With your specific question, is the situation I think where the heirs are aware of?
Yes, they know.
They know.
Yes, they know.
Okay, and do they? I suppose it's then finding it where it's held.
Yes.
Is it in an individual wallet, or is it in Coinbase,
It
or a platform, or they don't know where it's held?
No, they don't know. They just know that there is such property that the descendant disposes of.
And so it's held by the person who's passed away. They just don't know where the wallet is. Because where my experience is more recently is in relation to, say, bankruptcy proceedings, where I'm acting for a trustee in bankruptcy. Similar situation where we know there's a wallet in existence, but the way to find, if it's on a platform, makes it, not saying it's easy, it makes it easier, because you can approach the platform to find out information. Where it's in a wallet, what they've had to do is try to go through the bank statements to assess when monies were being transferred to purchase crypto, and then it was tracing it that way. But so if it's via a platform, I think it's easier. But if it's a wallet, they're very difficult to trace. And so I think if you can get access to things like bank statements and things like that, that would certainly help trace where the funds went. But any of you guys had experience with that?
But is there actually, to go further, is there any decentralized authority, which is a unified authority, that might answer the question?
Not that I'm aware of. I think that's, I suppose, part of the reason why people are using wallets to hide things.
No, but it's not. It's a different reality already. If you are supposed to make a due deal and the KYC procedure with the person who actually disposes of a stable coin, it means that you are supposed to know the person, who is who is making the transaction. So the person is not unknown anymore. Well, that's at least what Mika says, that they are not incognito anymore, so you are supposed to know who the person is, who the parties of the transaction are, and the crypto is an ordinary property or security depending on the jurisdiction. Then what happens with the rest of civil transactions that usually take place with the intervention of ordinary property?
Yeah. I think it's a great question. I just wish I had a much better answer for you. As chaps, have anything else to add on that?
We're hiding.
Oh, they're hiding.
Yeah,
as
he needs a bailout. We aren't giving it.
But it's something I'd love to look into, and perhaps we could chat about it afterwards. Yeah.
Thank you.
Great question. Any other questions from that?
Easy questions, please.
Easy questions. Then them over there, and then we move on to the general interest. As well. Okay. That one.
Can I proceed?
Yes.
I am from Bangladesh. I have this very simple question: is AI going to be threat for international arbitration process as well as legal litigation systems? AI is going to be a threat for us
As lawyers? As lawyers?
as a lawyer. Okay, thank you.
I shouldn't have clarified. I think John touched on this when he was speaking. I think the biggest threat that AI has is that you violate your confidentiality obligations for arbitration. You're putting stuff in there which is now not protected, and yes, maybe there's an element of there's so much stuff coming out in the award that maybe you can't pass through it. But to me, the biggest issue with using AI in an arbitration is that what is touted as an absolutely confidential proceeding is now no longer that. So to that extent, I think that's the biggest problem with AI in arbitration. In terms of, if your question goes deeper as to how it impacts lawyers, I think it's a discussion for another day and time, but hopefully not for a while, at least till I retire.
Anyone else wants that? Okay, gentlemen, and
Excellently.
oh, sorry. Oh, okay.
I am Mohammed from Pakistan as a practicing lawyer. First I would like to thank you that it was a wonderful talk. I would request if you could comment that the International Convention, New York International Convention on International Arbitration, that it needs to be revised or reviewed in the present circumstances of that social and economic issues that the world is facing. Just your comments on this convention.
New York Convention on the Enforcement of Awards.
Oh, wow. What's this like?
I don't think, I think so far it covers everything as far as enforcement goes. The only thing is that if it comes to include this effect of sanctions and things like that to include in the New York Convention, I think that may be something which can be considered, but I don't see any broad need that New York Convention on Enforcement of Awards at this time needs. That's what my views are, if John wants to add.
Yeah, I would agree with that. I think the New York Convention works pretty well. There are differences in countries. In some countries, it's a lot harder to enforce an award or to have an award recognized and eventually enforced than in other countries. Italy is harder than France, but that's the way it is. And I don't think there's any real need or any movement to change or amend the New York Convention.
Please.
Okay, my name is Liman A. Mohammed from Ghana, and my question is on the role of online dispute arbitration on cross-border and international arbitration. Africa has established what we call the African Continental Free Trade Area, where the African countries are supposed to encourage trade among nations. There is a dispute resolution system at the state level, but when individuals have challenges as we speak, there is no dispute mechanism. There is growing discussion around the possibility of considering online dispute arbitration because of the cross-border nature, considering the cost and all the disadvantages that we have discussed here. I want to find out, with the advent of AI, are there prospects for us to consider online dispute arbitration? And what is the trend from various continents based on your experience? Thank you.
I'm going to give a short answer. Yes, there are. Online dispute resolution is gaining in popularity. And since I don't want to get into what Ravindra and I will be speaking about tomorrow, I will just ask for you to show up tomorrow for a panel on this very subject. I'll let you.
Yeah, we have a topic session tomorrow on discussion.
I suppose these gentlemen don't want to give it away too much.
But the answer is yes. It's growing in popularity.
Maybe Dipesh or Palash, if you like that.
No, let's wait for them tomorrow.
Okay.
We'll share them tomorrow.
Good. Okay. Any other final questions, perhaps?
Yes.
That one broke no opposition.
So we can have last one question.
Hi, I'm V. Shruti Devi from India, more of a politician from the Indian National Congress Party, but I used to work full-time in the Supreme Court in 1997 for the Additional Solicitor General of India. So I work more on policy, and my co-panelists tomorrow are going to deal with technical aspects of AI. So first of all, let me flag that there's going to be more detailed discussion on AI tomorrow when I moderate that session. And I don't know, I can't remember now if there's going to be a full session on cryptocurrency, in which case I won't take this lady's question, colleague's question further. But if not, I would really like to flag, I don't think we can really laugh off some aspects of what we're being asked about, because it deals then with how you tax cryptocurrency. And in my country, in India, and particularly in some states of India, like Andhra Pradesh, where I come from, which is very tech positive, though I'm in the opposition, but I would still say that, is everything to do with cryptocurrency is being brought aboard. So I think you need to look at domestic legislation and how, and we as a lawyers forum, if we're looking at what our role is, I think there are great topics being discussed, and every time there's a question that really can't be answered, I think we need to, this is my humble suggestion, that we then make some suggestions in terms of what recommendations, concrete recommendations this forum comes up with. And one I would certainly think is calling upon all countries to come up with domestic legislation for cryptocurrency to put it, to make it taxable. Because I'm very keen, I don't know how many people are keen on making things taxable. But as a country that was, we are still a socialist, secular democratic republic in India. So, though we love to promote globalization of the economy, we also want everything to be taxed so that it then goes back into things like healthcare and getting the correct kinds of science for vaccinations for people across the world, including Nigeria or wherever it is. So, yes, so I would say that we need, in India, there's definitely an effort to, try to monitor. So we need to then, as lawyers, I think say that there is a need for further research and monitoring of cryptocurrency. The legal community thinks this. And in order to bring it into the tax structure, I would take the tax structure angle for this, and then you gentlemen would need to look at how that works with cross-border arbitration. Thank you so much.
Thank you.
Yeah, thank you. Thank you for that comment, very helpful comment. I think that would be the last question or comment from the audience, is it? Can I check the committee? Is that the last? Okay. Well, thank you. Thank you for your time and attention. I know we've covered a lot of topics in this panel, and I hope it was a helpful and insightful discussion. Thank you also to the panelists as well as the committee. Thank you.
Thank you. Please may I now invite the moderator, Nico, to present the mementos to the panellists. Thank you. We have John Lowe.